Comes, how do you know in the future what you did? And I think that's the issue of record keeping. And the record keeping is required by law. It's also going to be required for any defense of any claims that come later, unless your memory is a lot better than mine. So proper record keeping is essential for effectively defending claims of discrimination and other violations of labor and employment laws. So Courtney, if you could just briefly discuss that, what's required, what best practices are, and why proper record keeping is so important.
You're absolutely right, Mike. So good record keeping is essential if you're going to run a strong business, whether you're a private or a public employer. And part of good record keeping is record retention. Record retention gives an employer a clear and effective document retention program or policy so that they can, delete outdated and unnecessary information or keep up with different changes and amendments to statutes. It also protects them from, like you said, civil and possibly criminal liability if something were to arise. When an employer is developing their record retention policy, they have to be mindful of a number of different statutes, whether they're federal or state, because each statute has their own record retention criteria. So whether it's the Fair Labor Standards Act, the ADA, HIPAA, OSHA, the Bullard-Plawecki Employee Right to Know Act, all of those have their own criteria on what needs to be retained, how it needs to be retained. And how those statutes are going to apply is going to depend on a number of different things, right? How many employees an employer has. I believe if you are an employer with 15 employees, for example, the record retention requirements outlined in Title VII might apply for you, but it might not apply if the Age Discrimination Act might not apply to you because you have 20 employees. Because of the unique makeup of these different statutes, employers always want to be mindful of the various statutes that are defined. How many personal records in one statute may not be considered the same in another. This usually comes up with documents related to disciplinary matters and grievance investigations. So under the Bullard-Plawecki Act, employers who believe their employees engaged in criminal activity that resulted in an investigation may keep a separate file of information relating to that investigation. Once the investigation is complete, assuming there's no disciplinary action that is taken, the file can be destroyed. If the employer is a criminal justice agency, however, those separate files must be maintained regardless of the outcome of the investigation and may be released to MCOLs, for example. So again, it just really depends on the employer, the number of employees, what statutes might apply, but they're all very clear on what records have to be kept, how long those records must be retained, and how such records may be retained, so electronically or hard copy. And then the last thing I just want to touch on really briefly is for our government agencies that are joining us. Under Michigan law, the destruction of public records without the authorization and approval of a retention and disposal schedule is prohibited. So those kinds of schedules identify how long records must be maintained by the respective agency, the method of the disposal to avoid the destruction of those documents. These schedules cover a whole host of different public records, which I could talk about for a really long time, but they also talk about human resources and personnel files. In most cases, government agencies are covered under a general retention schedule, which can be found on the Michigan Department of Technology Management and Budget website. But if those general schedules don't apply or address every single record the agency has, then it's really important that the agency specify in a specific schedule that they will have to draft and then submit to the state and get approval on how they intend to handle those records.